So, Assalamualaikum. The articles that I will discuss are articles 30 to 49. So, the first article that I will discuss is Article 30, which is marriage after three talak. Number one, where a wife has been thrice repudiated, talak bayin rubra, on three different occasions by her husband, he cannot remarry her unless she shall have married another person who divorces her after consummation of the intervening marriage and the expiration of the iddah. No solemnizing officer shall perform the subsequent marriage mentioned in the preceding paragraph unless he has ascertained that there was no collusion among the parties. So, in the event that the husband repudiated his wife for the third time in a separate and distinct occasion, the repudiation become immediately final and absolute. He is prohibited to take her back during Ida, but even after the end of her Ida, he cannot remarry her unless the following conditions shall be fulfilled. First, the wife shall be subsequently married to another man, which is permanent in nature, not a collusion to circumvent the law. Second, the marriage must be consummated by sexual intercourse or dukul. The marriage is dissolved either by divorce or death of the husband. And lastly, after the lapse of the prescribed period of Ida, the wife may marry her former husband. So this provision found a basis in the following Quranic ayah to the effect that a divorce is only permissible twice. After that, the parties should either hold together on equitable terms or separate with kindness. So the underlying reasons why the third divorce is irrevocable of the higher degree is grounded on the fact that Islam gives the husband and wife two chances of revocable divorce. If he divorces her for the third time, the implication is that they cannot live together anymore. So the conditions imposed for them to remarry is almost impossible to meet. So our Article 31 is about void marriages. So void marriage under the Muslim code awards no right and impose no obligation. So the following marriages shall be void or batil from the beginning. Those contrary to Article 23, 24, 25, and 26. Those contracted in contravention of the prohibition against unlawful conjunction, and those contracted by parties, one or both of whom have been found guilty of having killed the spouse of either of them. So in paragraph A, which deals on Article 23 to 26, refers to prohibited marriages by reason of consanguinity, affinity, fosterage, and unlawful conjunction. Paragraph B, which deals on unlawful conjunction, is provided under Article 25. So the source of these are the sources of Article 31, paragraph B. So prohibited to you in marriage are two sisters in wedlock at one and the same time. And also in a hadith, it mentions that no one should conjoin in marriage his wife and her father's sister, or his wife and her mother's sister. Paragraph C is adopted from the Civil Code. To apply the said disqualification, the following rules shall be observed. If a person kills his own spouse intentionally, he is no longer qualified to marry again, whether the purpose of the killing be to marry again or for some other reason. However, if the killing is accidental or through negligence or justified, as when the victim had been caught in flagrante delicto in carnal conversation with a lover, this disqualification does not apply. And if a person kills another spouse intentionally for the purpose of removing the husband as an obstacle to the marriage, he cannot marry the widow. If for any other reason, the disqualification does not apply. So, this disqualification is a civil liability to be imposed only after the spouse has been convicted for a crime of either parricide, murder, or homicide. So, dapat convicted talaga yung spouse, charged na spouse. So, let's go to Article 32. It talks about fasid marriages. The following marriages shall be irregular or facade from their performance. Those contracted with a female observing Ida, those contracted contrary to Article 30, those wherein the consent of either party is vitiated by violence, intimidation, fraud, deceit, or misrepresentation, those contracted by a party in a condition of death, illness, marad or mult, without the same being consummated, those contracted by a party in a state of ihram, and a mixed marriage is not allowed under Islamic law. So in paragraph A, it pertains to a marriage contracted by a widow or a divorcee who is required to observe Ida before the subsequent marriage is contracted. Um, a source of paragraph A is a verse from the Quran which states that do not resolve on the tie of marriage till the term prescribed is fulfilled. Yung paragraph B naman pertains to marriage after 3 talak. Um, so if a husband divorced his wife irrevocable, he cannot after that remarry her until after she has married another husband and he has divorced her. Paragraph C pertains to vitiated consent of violence, intimidation, fraud, deceit, or misrepresentation. So these are concepts under the Civil Code, which are grounds of the annulment of voidable marriage. They are now incorporated in the Muslim Code as the grounds for making the marriage irregular. So violence refers to physical coercion, while intimidation refers to moral coercion. So the Civil Code speaks of three circumstances, any of which constitutes fraud, deceit, or misrepresentation. They are the following: misrepresentation as to the identity of one of the contracting parties, non-disclosure of the previous marriage, um, uh, non-disclosure of the previous conviction of the other party of a crime involving moral turpitude, with the penalty imposed was imprisonment for 2 years or more. The crime involving moral turpitude refers to the crime of yung dishonesty and immorality, kagaya ng adultery, fornication, rape, theft, and etc. And lastly, concealment. Concealment by the wife of the fact that at the time of the marriage, she was pregnant by a man other than her husband. Um, Paragraph D provides the condition of a death, illness of a party without the same being consummated. So, death, illness means the disease which caused death. So, in order to constitute a death, illness, the following conditions are necessary. The illness must cause the death of the deceased. The illness must cause apprehension of death in the mind of the deceased, and there must be some external indicia of serious illness. The condition of death, illness per se is not really legal impediment to marriage. It only makes the marriage irregular when death takes place without consummation. But should there be a consummation afterwards, yung marriage magiging valid. So this is a provision of the law that non-consummation of marriage due to death of either of the spouses is the cause of its irregularity. Paragraph E pertains to those contracted by a party in a state of ihram or in the state of ritual. So, ihram signifies the state of ritual consecration of a person while on pilgrimage, Hajj, or Umrah to Mecca. It begins from the moment that the pilgrim assumes his or her distinctive garb with the intention of doing Hajj or Umrah as the case may be until he or she lays it aside. So lastly, paragraph AF, which pertains to mixed marriages not allowed under Islamic law, or marriage to a non-Muslim in the case of a female Muslim, or in the case of marriage with a polytheist. There are two types of mixed marriages, which are not allowed under Islamic law. They are the following. So, yung marriage between a Muslim male and a non-Muslim female except kitabiya or yung the people of the book. This includes infidels, polytheists, idolaters, fire worshippers, star worshippers, pagans, or atheists. The Muslim code considers the prohibition of marriage between a Muslim male and a non-Muslim female except kitabiya as a temporary in nature in the sense that should the non-Muslim change her faith either to Islam or to the revealed religion like Christianity or Judaism, yung prohibition it will cease. So the marriage a marriage contracted in violation of such prohibition is considered under the Muslim code as an irregular. So next is marriage between a Muslim female and a non-Muslim male, regardless of whether he is a kitabiya or not. So the source of paragraph F is a Quran verse which states that do not marry unbelieving women, idolaters, nor marry your girls to unbelieving idolaters until they believe. So let's go to Article 33, which is the validation of irregular marriages. So, irregular marriages may be made regular by a new marriage contract in the following cases. Those referred to in Article 32, Paragraph A, after the impediment has been removed, or those observing IDA by compliance of the period required. B. Those referred to in Article 32B upon compliance with the requirement of Article 30 or by observing the tahlil. So C. Those referred to in Article 32C after the causes vitiating consent have ceased. So this is within 4 years after the state of violence ceased or intimidation has ceased. So D, those referred to in Article 32D, in case the party recovers. So if the husband who is who is having an illness recovers and affirm the marriage or consummate the marriage. So E, those referred to in Article 32E, when the party is no longer in a state of ihram, and F, those referred to in Article 32F after the conversion to a faith that could have made the marriage valid. The effects of the new marriage under the first paragraph shall retroact to the date of the celebration of the irregular marriage. So this pertains to yung children born out of the irregular marriage. They are still considered legitimate. The sources of Article 33 are Quran verses which states that and do not consummate the marriage until the term prescribed is fulfilled. Whomsoever is minded to perform the pilgrimage therein, let him remember that there is to be no lewdness. Do not give believing women in marriage to idolaters until they believe. So next is Section 5, Rights and Obligations Between Spouses. So Article 34 of the Muslim Code provides for mutual rights and obligations between the spouses, which are as follows. The husband and the wife are obliged to live together, observe mutual respect and fidelity, and render mutual help and support in accordance with this code. The duty to live together presupposes the idea that they have already their own residential place or lodging house to live in. It connotes cohabitation or marital consortium, living together under one roof as a husband and wife. In addition, they are obliged to live together in an atmosphere of peace and serenity. It is also the prime duty of a wife that in matters relating to the well-being and solidarity of the family or in matters affecting the happiness of its members, she must follow the instruction of her husband. So second, when one of the spouses neglects his or her duties to the conjugal union or brings danger, dishonor, or material injury upon the other, the injured party may petition the court for relief. The court may counsel the offender to comply with his or her duties and take such measures as may be proper. Neglect of marital duties will merit a court petition for relief. Should the wife, for instance, refuse to live with her husband without justifiable reason, upon the petition of the husband, the court may counsel the wife to comply with her duties. Should she fail to comply with the counsel of the court, the husband may stop giving her support. On the part of the husband naman, if the husband fails to perform for 6 months without reasonable cause his marital obligation, the wife may petition the court for divorce by fasok. Yun. So, Article 30, Paragraph 3, the husband and the wife shall inherit from each other in accordance with this code. But this is not absolute, though the spouses have mutual rights to inherit from each other. There are, however, impediments to its enjoyment. So, lastly, the husband and the wife um, shall have the right to divorce in accordance with this code. The sources of Article 34 includes the following Quranic verses: keep them in good fellowship, feed and clothe them, the wives therewith, and speak to them words of kindness and justice. Men are the protector and maintainers of women because Allah has given the one more strength than the other, and because they support them from their means. Therefore, the righteous women are devotedly obedient and a guard in the husband's absence what Allah would have them guard. Another source is that, O people, follow my advice concerning the kindly treatment of wives. I charge you to treat your wives with kindness and love. Better among you are those who are kind toward their wives. O you people, you have same rights over your wives as they have over you. So next is Article 35. Rights and obligations of the husband. The husband shall fix the residence of the family. The court may exempt the wife from living with her husband on any of the following grounds: her dower is not satisfied in accordance with stipulations, or the conjugal dwelling is not in keeping with her social standing, or is for any reason not safe for the members of the family or her property. From the foregoing provision of law, the husband is obliged to provide a suitable matrimonial home for his wife and his family according to his means, so that they may reside therein freely. It may be inferred also that the wife is obliged to live with him in the matrimonial home. She can only refuse to do so upon concrete and valid reason. Next is Article 36, Rights and Obligations of the Wife. First is that the wife shall dutifully manage the affairs of the household. She may purchase things necessary for the maintenance of the family, and the husband shall be bound to reimburse the expenses if he has not delivered the proper sum. This must be strictly interpreted. It is only allowed in case of necessity and after she has obtained permission from her husband. Sources of this article are verse from the Quran as follows: the righteous women are devotedly obedient and guard in what husband's absence what Allah would have them guard. He shall bear the cost of their food and clothing on equitable terms. So second, Rights and obligations of the wife. The wife cannot, without the husband's consent, acquire any property by gratuitous title except from her relatives who are within the prohibited degrees in marriage. So here the gratuitous title refers to property acquired by donation, remission, or succession. So third, the wife may, with her husband's consent, exercise exercise any profession or occupation or engage in lawful business which is in keeping with Islamic modesty and virtue. However, if the husband refuses to give his consent on the ground that his income is sufficient for the family according to its social standing or his opposition is based on serious and valid grounds, the matter shall be referred to the Agama Arbitration Council. So another effect of a wife's going out to work without the permission of her husband is the loss of the right to maintenance. So the wife shall have the right to demand the satisfaction of her mahar. It must be noted that mahar or dower is an inalienable and imprescriptible right of a woman. It is inalienable because even without the separation of mahar during or before the solemnization of marriage, mahar is still demandable, which is called mahar mito or customary dower. The wife shall have the right to demand the satisfaction of her full dower if the marriage has been consummated, and one half of it if there is no consummation. So this paragraph is derived from the verse, and give the woman in marriage their dower. So 5, unless otherwise stipulated in the marriage settlements, the wife retain ownership and administration of her exclusive property. The wife shall be entitled to an equal and just treatment by the husband. In case the man has several wives at the same time, he should deal with equal and just treatment of all of them. So this refers to yung mga material aspects like giving support to sa lahat ng kanyang mga asawa, as well as yung day of companionship. So the sources of paragraph 6 are verses which are, and women shall have rights similar to the rights against them according to what is equitable, be the male or female. Live with them, the wives, on a footing of kindness and equality. So, section 6, which talks about property relations between spouses. So Article 37, the property relations between the husband and wife shall be governed in the following order: by contract before or at the time of the celebration of marriage, by the provisions of this code, and by custom. This provision is derived from the wordings of Article 118 of the Civil Code. A contract of a stipulation concerning the property relations of future spouses that may be entered into before or at the time of the celebration of marriage is called marriage settlement or antenuptial contract. It is intended to govern the property relation between the future spouses during the marriage. But if the parties to the marriage contract has entered into a marriage settlement that shall govern them during the marriage, then whatever is their agreement, provided it is not contrary to this code, the Muslim code or Muslim law, public order, public policy, and good customs, shall govern their property relations during their marriage. So, Article 38, a regime of property relations. The property relations of the spouses, in the absence of any stipulation to the contrary in the marriage settlements or any other contract, shall be governed by the regime of complete separation of property in accordance with this code, and in a suppletory manner by the general principles of Islamic law and the Civil Code of the Philippines. So under Article 119 of the Civil Code, which is suppletory, the future spouses may in the marriage settlements agree upon absolute or relative community of property or upon complete separation of property or upon any other regime. The regime of complete separation of property under the Muslim code may be defined as matrimonial property regime whereby each spouse shall own, possess, administer, enjoy, and dispose of her own exclusive estate even without the consent of the other. However, the court may, upon petition of either spouse, grant to the other the administration of such property. Sources of Article 38 are provisions of the Civil Code, which are Articles 212 to 214, which provides that Article 212 should the future spouses agree in the marriage settlement that their property relation during the marriage shall be based upon the system of complete separation of property, the following provisions shall supplement their marriage settlement. Separation of property may refer to present or future property or both. It may be a total or partial. In the latter case, the property not agreed upon as separate shall pertain to the conjugal partnership of gains. And Article 214, each spouse shall own, dispose of, possess, administer, and enjoy his or her own separate estate without the consent of the other. All earnings from any profession, business, or industry shall likewise belong to each spouse. So, as an exception to the general rule, the future spouses may adopt other forms of property relations through yung marriage settlement na in-execute nila bago yung marriage. But the Muslim code is silent on the form of property regime that may be provided in the marriage settlement. However, yung sa civil code, which is applicable in suppletory manner, pwede siyang absolute community property, conjugal partnership of gains, or partial separation of property, or any other regime. Should the future spouses enter into a valid contract of marriage settlement fixing the property regime following either of yung aforementioned forms of property regime, the law that should govern their property relation is shifted na to the family code, which is yung amendment siya ng civil code. So, Article 39. Separation in the marriage settlements. Every stipulation in the marriage settlements or contract referred to in the preceding article shall be void and without effect whatsoever should the marriage did not take place. However, stipulations that do not depend upon the contract of marriage shall be valid. Antenuptial property. The wife shall not lose ownership and administration of all properties brought by her to the marriage in the absence of any written agreement to the contrary, and she may dispose of the same by deed or otherwise, even without the consent of her husband. The source of Article 40 are these are the are a Quran verse which states that never will I suffer to be lost the work of any of you, be he male or female. To men is allotted what they earn, and to women what they earn. So, by the wife, antenuptial property refers to all the properties which she brings to the marriage as her own separate and exclusive properties. It is called paraphernal property. Since it is her exclusive and separate property from that of her husband, she retains the right to own, possess, administer, enjoy, and dispose of the same without the consent of the husband. She may sue or be sued independently of her husband concerning her exclusive property. However, the court may, upon petition of the husband, grant to him the administration of such property. But the mere fact that the wife transferred to him the administration of her paraphernalia property does not confer upon the husband the right of ownership of the same. The husband cannot, therefore, without her proper authority and any unauthorized act involving the wife's paraphernalia property cannot be given any force and effect as against her interest over the same. So let's go to Article 41 for the exclusive property of each spouse. The following shall be the exclusive property of either spouse. Properties brought to the marriage by the husband or the wife. All income derived by either spouse from any employment, occupation, or trade. Any money or property acquired by either spouse during marriage by lucrative title, the dower mahar of the wife and nuptial gifts to each spouse. Properties acquired by right of redemption, purchase of, or exchange of the exclusive property of either, and all fruits of properties in the foregoing paragraphs. So some of the sources of Article 41 includes a verse from the Quran: to men is allotted what they earn, and to women what they earn. So let's go to Article 42, ownership and administration. Each spouse shall own, possess, administer, enjoy, and dispose of his or her own exclusive estate even without the consent of the other. However, the court may, upon petition of either spouse, grant to the other the administration of such property. Article 43, household property. Household property which customarily pertains to or is used by either spouse shall be prima facie presumed to be the property of the said spouse. Um, a source of Article 43 is an Islamic jurisprudence which states that household property are articles of household which are not consumed not consumed in their enjoyment, but which are ordinarily intended to be used by either spouse for their personal convenience or purpose, or that of the household in common. Examples are wall clock, chinawares, house furniture, both useful and ornamental. As to who owns them, the present article provides a prima facie presumption that household property which customarily pertains to or is used by either spouse shall be prima facie presumed to be the property of said spouse. For example, kitchen utensils which are ordinarily used by the wife belongs to her. Tools used in his trade by the husband belongs to him. So Article 44, right to sue and be sued. The wife may, independently of the husband, sue or be sued in the following cases: when the litigation is between husband and wife, if the suit concerns her exclusive property, if the litigation is incidental to her profession, occupation, or business, if the litigation concerns the exclusive property of the husband, the administration of which has been transferred to her, or such other appropriate cases as may be followed by the general principles of Islamic law and other laws. Article 44 is based on a Quran verse which states, "And they, wives, have got rights similar to those against them in just manner." So let's go to divorce or talak. Divorce is a formal dissolution of the marriage bond in accordance with this code to be granted only after the exhaustion of all possible means of reconciliation between the spouses. Article 45 defines and enumerates the different forms of divorces that may be availed under the code. Divorce may be effected by repudiation of the wife by the husband or talak, vow of continence by the husband or ila, injurious assimilation of the wife by the husband, or zihar, acts of imprecation or lian, redemption by the wife or kul, exercise by the wife of the delegated right to repudiate or tafwud, or judicial decree or fasq. So it is important to note that divorce is only granted by the court after the exhaustion of all possible means of reconciliation between the spouses. Divorce is always considered as a last recourse. Amicable settlement of marital disputes is not limited between husband and wife, as it may also involve other parties, especially elderly members of the family. Sources of Article 45 are verses from the Quran and also Hadith, which states that all people, when you divorce women, divorce them at their prescribed periods. Thus, when they fulfill their term, appointed time, whether taking them back on uh, uh, equitable terms or part with them on equal terms, and take for witnesses two persons from among you endued with justice. And if you fear breach or shihak between them, the husband and the wife appoint an arbiter from her folk. If they desire amendment, Allah will make them one of mine. Also, a hadith, of all things allowed, divorce is the most hateful in the sights of Allah. So, Article 46, or divorce by talak. A divorce by talak may be affected by the husband in a single repudiation of his wife during her non-menstrual period, or to her, within which he has totally abstained from carnal relation with her. Any number of repudiations made during one to her shall constitute only one repudiation and shall become irrevocable after expiration of the prescribed ida. A husband who repudiates his wife either for the first or second time shall have the right to take her back or due within the prescribed ida by resumption of cohabitation without need of a new contract of marriage. Should he fail to do so, the repudiation shall become irrevocable or talak bain sugra. So, the above provision laid down some important principles regarding divorce. The first paragraph provides the condition of a valid pronouncement of talak that is to be made during the non-menstrual period of the wife. This condition is based on a Quranic verse which states, "O Prophet, when you divorce women, divorce them at their prescribed periods and count accurately their Ida periods." So the term prescribed period means period of purity or yung non-menstrual period. So a divorce or talak made during the menstrual period of the wife cannot be considered a valid pronouncement of divorce. Yung paragraph 2 also points out the husband's right to take back his wife in case of first and second pronouncement, as long as it is still within the Ida period through a resumption of cohabitation without a new marriage contract. These instances contemplate talak that is revocable, or the so-called talak bain sugra. However, if the Ida has already lapsed, the husband can only take back his wife through a new marriage contract. and he has to pay a new mahar or dower. If a husband pronounced divorce for the third time, um, and he failed to take back his wife during the Ida period, um, hindi na niya pwedeng mapakasalan ulit yung wife niya because it's in the third time already, as the divorce has become an irrevocable one, or yung talak bain kubra. An intervening marriage called yung tahlil could restore a husband's right to remarry his wife. So, tahlil is an Arabic term which literally means legalization or justification, and technically signifying the subsequent valid and consummated marriage contracted by an intervening husband with a wife who has been thrice repudiated by her former husband, and thereafter the intervening husband dies or divorces her, and after the expiration of the prescribed ida for death or for divorce, as the case may be, the former husband may remarry her. So, in other words, after 3 divorces, the husband is prohibited to remarry her. He can only remarry her by complying with the requirements of a tahlil. Um, so, marriage of the woman to another man after the third divorce gives a chance to her to have a new conjugal life, which may prove happy and satisfying to her. So, if on the other hand there were also maladjustment, their married life and separation takes place, the Quran has permitted her to be wedded to her former husband after the necessary formalities of a divorce from the second husband. Finally, talak is only a prerogative of husbands, as wives do not have the right to pronounce talak. Yung husband lang pwedeng mag-divorce through talak. But wives are given delegated authority to initiate divorce proceeding through tafwid under Article 51. So let's go to divorce by ila, where a husband makes a vow to abstain from any carnal relations or ila with his wife and keeps such ila for a period of not less than 4 months, she may be granted a decree of divorce by the court after due notice and hearing. Article 47 contemplates another ground for divorce, which the court may grant to a wife provided there is due notice and hearing. In other words, divorce by ila should be initiated by the wife provided the following elements are present, namely husband's vow to abstain from any carnal relation with the wife, and the husband keeps the vow for a period of not less than 4 months. So with these elements, if these elements are present, it is the prerogative of the court to decree a divorce. So a source of Article 47 is also a Quran verse, for those who take an oath of abstention from the wives waiting for 4 months is ordained. If they return, Allah is of forgiving, merciful, but if their intention is firm for divorce, Allah heareth and knoweth all things. So, divorce by zihar, where the husband has injuriously assimilated zihar, his wife, to any of his relatives within the prohibited degrees of marriage, they shall mutually refrain from having carnal relation until he shall have performed the prescribed expiation. The wife may ask the court to require her husband to perform the expiation or to pronounce a regular talak should he fail or refuse to do so, without prejudice to her right of seeking other appropriate remedies. So, divorce by zihar under Article 48 contemplates cases where husbands injuriously assimilated their wives to any of his relatives within the prohibited degrees of marriage. This is an important element of Article 48 in order for the case of divorce to prosper. Injurious assimilation means presence of malicious intent to malign the wife. In the case of zihar, husband and wife should refrain from having carnal relation. In order to resume cohabitation, it is mandatory or obligatory on the part of the husband to perform expiation. The wife may ask the court to require the husband to expiate or to pronounce a regular talak. In case the husband refuses to observe these two options, the wife may go to court for a decree of divorce and seek other remedies. These remedies include right to support or alimony for the minor children under the custody of their mother. Injurious assimilation of the wife by the husband to any of his above mentioned relatives constitutes zihar. Article 48 also mandated husbands to perform expiation in case he wants to take back his wife. Unlike the case of Ila, whereby a husband vows to abstain from carnal relations with her wife for a period of not less than 4 months, he could at any time within that period resume cohabitation with his wife, and expiation becomes obligatory. But in the case of zihar, the husband cannot cohabit with his wife unless he first performs the required expiation. This rule finds basis in the following verses. But those who divorce their wives by zihar then wish to go back on the words they uttered, it is ordained that such one should free a slave before they touch each other. There are you admonished to perform, and God is well acquainted with all that you do. And if any has not the wherewithal, he should fast for 2 months consecutively before they touch each other. If any is unable to do so, he should feed 60 indigent ones. This, that you may show your faith in God and his apostle. These are limits set by God for those who reject him. There is a grievous penalty. So the last article is Article 49, or divorce by Dian, where the husband accuses his wife in court of adultery. A decree of perpetual divorce may be granted by the court after due hearing and after the parties shall have performed the prescribed acts of imprecation or dian. So, a divorce by the end contemplates cases where husband accuses his wife of adultery in court. The accusation, if proven true or otherwise, results in the granting of a perpetual divorce after due hearing and trial. This provision is based on a Quranic verse which reads, "And those who launch a charge against chaste women and produce 4 witnesses to support their allegations, flog them with 80 stripes and reject their evidence ever after, for such men are wicked transgressors." And the fifth oath should be that they solemnly invoke the curse of God on themselves if they tell a lie, but it would avert the punishment from the wife if she bears witness 4 times with an oath by God that her husband is telling a lie. So the above verses prescribes the procedure for a divorce by lian, namely the appearance of the spouses before the court or a judge to bear witnesses 4 times with an oath to Allah that the husband is solemnly telling the truth, and to invoke a fifth oath of Allah's curse if he is telling a lie. So there is really a curse. So the wife also bears witness 4 times with an oath to Allah that her husband is telling a lie in his accusation against her, and the fifth oath to Allah that she solemnly invokes the wrath of Allah on herself if her accuser is telling the truth. So the wife also contradicts by making the same oath, the same four times as the husband did. So yun. Number three, granting a decree of perpetual divorce by the court. Another source of Article 49 is also a Quran verse which says, "And for those who accuse their wives and have no witnesses except themselves," ito naman yung mga walang witness, "let their testimony be repeated four times by Allah that they are solemnly telling the truth, and the fifth oath should be that they solemnly invoke the wrath of Allah on themselves if they tell a lie, and it shall avert the punishment from her if she bear witness before Allah four times with an oath that what her husband said is indeed false, and the fifth time should be that she solemnly invoke the wrath of Allah upon herself if he speaketh the truth." But in case the accusation is proven true, the utterers or fornicators shall also be punished on the ground of zina. Hadith of Prophet Muhammad sallallahu alaihi wasallam states that the spouses who accuse one another of adultery shall not join each other anymore. And another hadith also states that the spouses who throw the curse of Allah to each other in accusation of adultery shall be separated and shall not be joined together forever. It is impossible for the couples who go through the nuances, yung shame, the mental anguish brought about by this kind of accusation to live normal lives together. Therefore, yung divorce becomes a better recourse than staying together in misery. So, thank you for listening. That's it for my report. Um, Thank you and Assalamualaikum.